I suppose at the outset we have this big tome, 720 pages, a reform of our planning acts, and we have to ask, well, why do we have this? And it seems that a lot of us don't really know why. I mean, we know that there were problems with the planning system. We know that reviews were carried out. But we don't really know what those reviews found. I mean, they've never been published. Certainly there was a problem with An Bord Pleanála. There were a lot of cases in An Bord Pleanála that were taking a long time. But I suppose we don't know why those cases were taking so long. But it's not unreasonable to surmise that the reason they were taking so long is that they raised complex issues, and An Bord Pleanála lacked the resources to deal with those issues. But the Irish response to a lack of resources tends to be, well, let's bring in a law. Because it takes a lot of time and it takes a certain amount of money to bring in a law, but, a lot less time and money than it does to actually address the root cause of the problem. Now, Deputy Connolly, who spoke before me, and I must say I find myself in agreement with much of what she said, talked about the similarities in a way between planning and access to An Bord Pleanála and immigration judicial reviews. Now, various ministers for justice said the problem with immigration in Ireland is the challenges. We just can't deal with the challenges, so we'll tinker around with the rules and we'll bring in a new law and that'll change matters. And then it didn't, and then you change it back to what it was, and unsurprisingly, the problem is still the same. Alan Shatter was a Minister for Justice in this House. Minister, you'll recall him, you served in the parliamentary party with him. Now, he had strengths and weaknesses, as everybody does. But one of the strengths that he had was he didn't go with the usual canard of, well, I'll change the law. What he did was he resourced the decision makers. He resourced the citizenship section of the Department of Justice. So instead of spending all of their time and all of their resources in the courts justifying the bad decisions they were making, or even more problematically, justifying the fact that they were making no decisions at all, he resourced them to make decisions. And they made the decisions. And the problem didn't arise anymore. Now, much to the chagrin of some immigration lawyers, and I have to declare that I'm somebody who has practiced in immigration judicial review. But at least proper decisions were being made. The same was true of first instance decisions were being judicially reviewed, and it became more difficult to review first instance decisions. And instead of changing the law in that regard, he hired a lot of people to make first instance decisions. And he made sure that those people were trained to make the decisions. And guess what? The judicial reviews fell away because they were no longer making bad decisions. But the problem with An Bord Pleanála is they're making a lot of bad decisions. Now, how do we know they're making bad decisions? Well, we know that because they're not able to stand over the decisions that they're making in the courts when they're challenged. Now, if they were making proper decisions, and I'm not blaming individuals in An Bord Pleanála, I'm blaming the political system that has failed to resource An Bord Pleanála. Because if they were making decisions properly, they wouldn't be losing as many cases as they were losing, and then maybe there wouldn't be as many cases being taken, because it would be perceived that it's actually difficult to win against them because actually they're okay at their decision making, they're able to stand over them. But that's not where it's at now. And the response is to change the law to make it more difficult instead of to resource An Bord Pleanála. Because the reality is, Minister, unless you resource An Bord Pleanála, unless the decision making there improves, well, you still have the same problem. You'll just end up with a damaged environment because bad decisions will be made, but it'll be more difficult to challenge it. So you'll actually, through the use of the law, it's incredible that any so-called it's incredible that your partners in government have gone along with this. Because what will result is bad decisions being made that will be more difficult to challenge. Now I want to look into, we know also that there's a phenomenon of pseudo-objections in Ubor Planola. Now I have to say that works both ways. It's not just that there are people who make objections in the hope that they'll be bought off. There are people who make legitimate expectations, and developers offer them a bit of money and say, look, would you just go away, there's a few bob. So, I mean, one does feed the other, unfortunately. The fault isn't all on one side. And I'm intrigued by RTE's expose, but maybe I'm just here too long, and maybe I have a suspicious mind, and maybe the suspicious mind is because it comes from being a nefarious person. I don't know, but when a programme is timed to coincide with a bill, I often wonder, how does it, from an independent broadcaster, it's a happy coincidence at best. And I hope it's just a happy coincidence, because I'd like reassurance from RTE that this, which completely bolsters the case that you're making and that the Minister is making, that there's no, RTE is in a hole at the moment. It desperately needs money, it does. So I just hope that they're not doing the government a favour in the timing of this, and that the timing is entirely coincidental. That's all I want to say. But I do not in any way condone what was exposed. I mean, it is wrong and may well be criminal, and I hope it is investigated. I call upon any and all authorities to investigate it, and if it's not a criminal activity, then I think making objections for the sake of obtaining a financial benefit should be an offence, and should be made an offence in this Act. So that's one thing I would ask that the Minister does. In some of the time remaining to me, I just want to look through some of the provisions of the bill. But before I do, I've already spoken about the lack of capacity in Ubor Planola. The lack of capacity with respect to environmental decisions is even more profound, because you have developers where a development is a large-scale development that's going to impact, or has the potential to impact upon a designated site, a European site, of which there are many across the state, then an EIAR and an Natura 2000, all of this has to be done. And the developer will pay a consultancy firm to do it, and they'll submit that along with the planning application. But I've seen a number of these done over the years, but I've never yet seen one from a consultancy firm saying, under no circumstances should this development proceed because it's going to damage the environment. Because that's not how the world works. You hire a consultant, whether it's the Oireachtas hires one, or whether it's a government department, or whether it's a private developer. They hire a consultant to come up with a particular outcome. And a consultant who doesn't come up with an outcome that his clients want is very unlikely to be hired by the same client again, and less likely to be hired by any other client. Because this is these developments, by and large, are for profit. Most of the developments that are applied for are for profit. And consultancy firms have to come up with a decision that somehow justifies or somehow softens the edges of the impact that this will have. And on Ubor Planola, inspectors, very few of them have the expertise to go through those. They have to take them at face value and note what it says about the measures, and, well, they'll do. They're not in a position to second guess it. They're not in a position to interrogate it. And if we're serious about the environment, and if indeed the Green Party are serious about the environment, then we need, I think, that there needs to be these assessments, EIARs, Natura 2000 reports, etc., need to be referred to an independent state agency that has the expertise to look at the report and say, actually, that's a load of codswallop. With the greatest of respect, and I appreciate it was done by consultants, but it's a load of codswallop. Or, yeah, you know what, they're right. There are mitigation measures that can be taken, and this project can proceed without damaging the environment. But at the moment, we don't have that. We have an inspector who maybe an engineer, may have an expertise in architecture, but who's looking at this detailed report with no skills and no training to interrogate it, and is in a position that they have to take it at face value. And there's a particular, I suppose, impetus to take it at face value when it comes to strategic infrastructure developments, like housing developments, for example, because there's the government have said they're going directly to Onboard Pleanála, so it's not even, there's no filtering mechanism whereby they go to a county council first and the environmental department of a council who might have an ecologist or might have an environmental scientist working for them can at least interrogate it. That's not even there. Now, on this issue of strategic infrastructure development going straight to Onboard Pleanála, I mean, that's been an unmitigated disaster. And I see it's replicated in this bill, where applications can be still made directly to the board. Why are we replicating failure? I mean, it hasn't worked. I appreciate what it was intended to achieve, but it hasn't achieved that. Why are we doing it? Section 5s, I notice, are done away with. We want to lessen litigation, it seems, and yet we remove Section 5s. It's inexplicable why we're removing the Section 5 declaration process, or rather limiting it to the owner of the property or the potential developer. So now a person who has concerns about whether something is or isn't exempt to development, and often the most complex question around whether something is or isn't exempt to development is around whether screening is required. So now the only question mark will be, the only avenue will be the courts. So we want people to go to court less, and we take away the alternatives. It just doesn't add up. Again, no explanation, no outcomes of this review that was carried out as to how Section 5s were working, what was so wrong with how they were working that they needed to be removed. But they're being removed nevertheless, so they're going to force more people into court. A couple of other features of the bill which I just wish are problematic features of the bill. By the way, the bill isn't all bad. I mean, I do welcome the fact that there are timelines for Onboard Pleanála, but even with regard to the timelines, I raised in the context of my objection to this bill proceeding on the basis that the explanatory memorandum is hopelessly inadequate. I mean, in a 720-page bill, one might expect to be told, because the parliamentary draftsman and the department know exactly what provisions and what parts of provisions are restatements of existing law and what's new law. Like, why not share it with us? Why is it a secret? What do you gain by keeping that secret? Just share it and say, you know, whatever section and subsection is an exact restatement of the previous law, this is an exact restatement of the previous law, and then this next subsection, well, that's a new piece of legislation, which might encourage people to interrogate that a bit more. So, I mean, I listened with interest to what Padraig O'Sullivan, Deputy Padraig O'Sullivan from Cork, had to say, and he talked about, you know, these conspiracy theorists. But like, when you're trying to hide what's new in with there with a lot of what's old and not differentiate between the two, well, a little bit of suspicion is not unreasonable and is quite understandable. So can you please, Minister, or your Minister O'Brien, or whoever cares about this legislation, come up with a memorandum that shows us, that sets out in very clear terms what's a restatement of existing law and what modifications there are in this, and what new law there are in this 720-page tome to facilitate the lawmaking process. Because if I could go to the DAA, there's a whole part of the bill that attaches to the DAA. I noticed that the application shall be made to a competent authority. It doesn't say who the competent authority is. I mean, I'm assuming that the competent authority is the same one as as in the bill that's being, is it the amendment to the 2000 Act, or the 2000 Act that's being repealed, but again, it's not clear. One of the more contentious areas is around appeals to the Supreme Court appeals to the superior courts, i.e. appeals to judicial reviews generally, and the necessity to cut them down. I mean, a lot of them are successful, as I've said earlier. But if they're successful, that points to problems in the decision-making process. Or else we, the legislature, are saying, well, we don't like the courts down there. Now, that's a pretty big statement to be making if that's what we're making. I don't think it's what the government is going to make overtly, or we don't think that we don't like the fact that the court is finding so many of these judicial reviews are being upheld. Because it's for the courts to determine whether the procedure was followed properly, whether the decision was properly made. They found in the majority of cases they're finding, well, I suppose they're the majority of decided cases. In fairness, there are cases that are withdrawn and fold, but in a large proportion of cases they're finding they're not. So I have concerns about anything that impedes access to justice. And your government will talk about the importance of access to justice, and it's great, we need to deal with this, that and the other. And on the other hand, when access to justice doesn't suit an agenda, and I'll talk about the agenda in a couple of minutes, well, then you impede access to justice, and it is being impeded in who can take a case versus who couldn't. It's not maybe as draconian as it might be, but I would be concerned about the whole. It says, section 259 specifically says, no appeal to the Supreme 259.2. No appeal to the Supreme Court shall lie for the determination of the High Court in Part 9 judicial review proceedings, save on the basis of an application for leave to appeal under Article 34.5.4 of the Constitution. I don't know why that's needed to be stated, because you can't appeal in any event directly from the High Court to the Supreme Court other than in accordance with that provision. So it seems a bit superfluous. Maybe something is meant by it. If it is, I'd like to know what it is. Or maybe it's just a piece of inelegant drafting. But I'm just asking, is something specific meant by it other than that which it states? Because it needn't, in my view, be stated. Then these costs that can be awarded, the costs, I suppose it is regarded, maybe somewhat unfairly, that there's an inequality of arms at the moment, in that, or at least an inequality in that the applicants will frequently not be earmarked for costs. There'll be a residence group or a loose association that can't be pursued for costs, and even if they weren't a loose association, even if they were a legal or a natural person, well, you can't pursue them for costs anyway if it's an environmental type planning case under the Aarhus Convention and the Supreme Court's relatively recent finding in the Meadow Hill judgment. But that said, there's a danger that the pendulum is going to swing too far the other way, because you're only going to allow costs that are allowable in accordance with Section 266. And those costs will be determined by the Minister for Environment, Climate and Communications after consultation with the Minister and the Minister for Justice, and with the consent of the Minister for Public Expenditure, National Development, Plan, Delivery and Reform, who I suppose maybe has a vested interest in limiting judicial reviews because they might be slowing it down. So the man who's going to write the cheques, or woman, but it's men up to now who've held that office, have probably a vested interest in keep the money down, want to deter judicial reviews to the greatest extent possible, want to actually make it financially unviable for people other than those with very deep pockets to access them. And I want to make sure that council and legal teams, even when they take on the gargantuan task of challenging a huge infrastructural development like that, even when they win, well, we're going to give them very low costs. Now, if you're serious about this being a real measure, then at the very least, included in the consultation should be the Law Society and the Bar Council, because they will at least know what costs are reasonable in the circumstances and what aren't. Because here, I don't know whether you're, do you know my cousin Vinny? I don't know whether you've ever, you don't know, well, I don't have a cousin Vinny, but I've seen the programme, and what we don't want... I don't actually know your cousin Vinny, I know Phil. Exactly. And what we don't want is a scenario like my cousin Vinny, where you have very high-powered legal teams on one side, and because the costs that can be obtained are so low on the other, that you have, because we've never had an inequality of arms in Ireland. Minister, you can come back a very limited time, but in every... Sorry? Vinny won the case, but this was Hollywood. There are many Vinnies who don't, and the Innocence Project in America, where there are lots of people who claim they were badly... There are people in jails in Ireland too who claim they were badly represented. But what we want to make sure is that people aren't deterred on the basis of that fees are not intentionally driven down so as to make it almost impossible to mount a challenge on an environmental basis, because that would be incredibly cynical, incredibly detrimental. And you know, as bad as the Greens are, or as good as the Greens are, they are quite effectual. I'll give them that. They won't always be in government. I mean, I've learned that from my limited time in here. The governments change. There could well be a government that is a lot more hostile to the environment and environmental challenges, and a minister who's determined to build a motorway to every province, every provincial town in Ireland. Imagine how they'd feel about that if they were involved in campaigns or legal challenges to those, and they couldn't get lawyers to represent them because the fees were so bad. Because we've always, even through the downturn, made sure that there was an equality of arms with regard to criminal justice. I do recall, I'm going to finish on this point. I can have a couple of minutes of Deputy Fitzmaurice, as he's told me.
20 minutes is the max you can have.
Sorry?
20 minutes is the max you can have.
He'll give me 2 minutes of his.
But anyway.
Brendan, there were fees to the criminal defence payment, and there was an argument. The Bar Council approached Deputy Howland, was the Minister for Public Expenditure at the time, to say that there's an inequality of arms, that prosecution lawyers are getting a little bit more than defence lawyers. So he remedied that by cutting the other as well. But at least there was an equality of arms. Whereas that is, for the first time, being challenged in this, and that's a huge concern. Thank you.